So, have you ever wondered what really happens when you decide to take on your homeowners association? Well, we're going to break down a real legal dispute to see what goes down when rules are broken, lawyers get involved, and neighbors end up facing off in a formal hearing.
All right, so this whole explainer is built from the real deal. We've gone through the official court documents and the hearing transcripts from a case that just unfolded in 2023. Let's meet our players.
So, on one side, you've got the homeowner, R.L. Whitmer, and on the other side, the Hilton Casitas Council of Homeowners, his HOA. This is pretty much the classic setup for a neighborhood showdown.
Now, Mr. Whitmer didn't just have one complaint. He had two separate petitions that actually got rolled into a single hearing. He was basically alleging that the HOA violated the rules in two key ways. So the big question is, what were his arguments?
All right, let's get into the first complaint. It all boils down to something that sounds super simple, but is actually critical: a deadline. So Mr. Whitmer's first point was, incredibly straightforward. The HOA's own bylaws, their own rules, said the annual meeting had to be held by March 31st. And when did they hold it? April 27th. That's 27 days late. Pretty cut and dry, right? And in the hearing, he really hammered this point home, arguing that this wasn't just, a simple mistake. He saw it as part of a pattern, a board that was just lax about its legal responsibilities. So you have to wonder, right? How on earth did the HOA respond to missing such a clear deadline? Well, get this. The HOA's lawyer basically came out and admitted it. Yep, they were late. But she called it a technical violation. And then she argued the whole complaint should just be thrown out because, hey, the meeting already happened. In legal terms, she said the issue was moot. And this quote from her, it just perfectly illustrates their whole point. I mean, you can't force them to hold a meeting in the past. It's impossible. What's done is done. Okay, so this introduces a really important legal idea here, one that the HOA's whole defense kind of hinged on. So let's talk about it. What does it actually mean when a case is moot? Basically, it means there's no real live problem for a court to solve anymore. The controversy is over. So the HOA's logic was, yeah, the meeting was late, but it happened. It's done. So there's literally nothing left for the judge to rule on. All right, but hold on, because the late meeting was only part one of the story. The second complaint, this one goes beyond just the community's own rules and gets into actual state law. And it's all about how people were allowed to vote. So here's the deal with his second petition. He claimed that because the meeting was held only on Zoom, the HOA broke a specific Arizona state law, a law that says members have to be given an option to vote in person. And his argument was pretty bold. He said, look, the meeting format was illegal from the get-go, so why would I have to participate in it? I don't have to show up or even object to something that's already breaking the law. But the HOA, they came back with a really powerful counterargument. Their lawyer pointed out that Mr. Whitmer got the notice about the Zoom-only meeting almost a month ahead of time, and he never said a word, not a single objection. So, she argued, by staying quiet, he legally waived his right to complain about it later. And boom, that brings us to another one of these super important legal terms, a term that really ended up deciding how this whole part of the dispute played out. So what it means here is basically this. The HOA was saying if you see something wrong with how an election is being run, you have to raise your hand and say something before it happens. You can't just wait until after the votes are counted and then complain. It's kind of a speak now or forever hold your peace kind of deal. Okay, so we've heard arguments from both sides. We've got these big legal ideas of mootness and waiver floating around. So how did the judge rule? Let's break down the final decision. First up, the late meeting. The judge sided with Mr. Whitmer, found that, yes, the HOA absolutely violated its own bylaws. They were 27 days late. So that's a clear win for the homeowner, right? Well, not so fast. Because even though the judge said, yep, you broke the rule, the penalty he imposed was a big fat 0. Nothing. Okay, so what about the Zoom-only vote? Well, same story. The judge found that, yes again, the HOA violated state law. They were supposed to provide an in-person option, and they didn't. So what's the fine for breaking a state law? You guessed it, $0. Again. So the judge confirmed the HOA broke the rules on both counts, but decided not to fine them for either violation. Wow. So why? Why no penalty? Well, the judge's reasoning pretty much mirrored what the HOA's lawyer argued. The homeowner, Mr. Whitmer, couldn't prove that the board was acting maliciously or in bad faith. Basically, the judge saw these as mistakes, procedural slip-ups, not some evil plot to hurt homeowners. Okay, so after all that, what's the takeaway? What can we, as homeowners or maybe even board members learn from all this? This case really hammers home 3 huge lessons. Lesson 1. Object early. If you see a problem with how something's being done, you have to speak up right away and get it on the record. If you don't, you might lose your right to complain later. 2. Know the rules. Seriously, your bylaws and state laws are your best friends. And finally, number 3, just because you prove someone broke a rule doesn't automatically mean there's going to be a penalty. You often have to prove why it deserves a penalty, and that's a much harder fight. And that really leaves us with one last big thought to chew on. This whole thing with the lawyers, the court filings, the formal hearing. At the end of the day, this was a fight between neighbors. It just makes you wonder, right? Where's the line between holding a volunteer board accountable for every little thing and just being a good, functional community?